I just need a little point on my map that it grounds us. How are you all? Week 2, everybody getting their heads around it? Everybody getting themselves sorted, understanding what's going on? Have we got any OUA people in the room today?
It's me.
Me. Okay. Are you Jonathan?
Yes, I am.
Thanks, Jonathan. Yeah, just thought I would say a particular hello to our OUA friends because they are suffering through the introduction of a brand new learning management system, which I think will be awesome. I think it will be truly, truly awesome, but it's got some growing pains associated with it. And yeah, so please point out to me when I'm doing things wrong, because that'll happen. Okay, today, what are we going to do? We're going to start our 2-week journey into Opera. Exciting thing in my life, I worked out that PowerPoint has this whole new piece of functionality I found, which makes your PowerPoint a bit like a Prezi without it being sort of making you nervous and nauseous. And so this is way too busy because it's a very big topic that we're about to cover. But this lovely slide here, each of those little pictures links to the relevant bit on the presentation. So I'll be able to work out where we're going, sort of maybe. So basically, ready to start? We are going to talk about agreement. Oh, that's right, I can do that with my finger. So, before we actually start talking about agreement, I'm going to do a little bit more talking about why we're talking about agreement and why we're going to do this deep dive. So, I want you to understand, and I know I spoke about this a lot last week, about this idea of us unpicking each of the jigsaw puzzle pieces and really getting our heads around what each of them mean before we get a sense of what the real picture is. There was one piece I don't think we really spent that much time on, and some of you who've done other subjects will get this straight away, but just bear with us for the beginning. Essentially, what you need to be able to do for your exam, for your assignment, and actually in the real world, is you need to be able to unpick a contract problem. Now in this class it's easy to recognise you've got a contract problem. I am not going to be asking you a topics problem in this class. So, and similarly in the exam, you can be pretty sure that the problem that you have is a contract problem. Some of you will find other ways to read it, that's fine, but like if in doubt, it's a contract problem. In the real world, your clients will come to you with a problem that might not even be a legal problem, much less for you to work out whether it's a contract or a tort or a privacy act or whatever kind of problem it is. So what we need to do is, once we know we've got a contract problem, we need to be able to unpick how to solve a contract problem. And essentially, this is what I'm asking you to think about. Firstly, is there a contract at all? So before we can work out whether somebody has breached contract or somebody's got rights under a contract, we need to know whether there's a contract at all. And hint, we're going to spend almost half the semester exploring that problem. So chances are at least one, if not all of your assignments and exam questions in some way will be looking to that question. Is there a contract? We have a contract here. Once we know whether there's a contract or not, so no contract, there are special sets of rights and obligations that attach to that, and on purpose being quite broad at the moment. But once we have a contract, then we ask, who can sue on the contract? Who has privity? So again, we'll deal with that particularly when we look at privity. If there isn't a contract, a legal contract, an enforceable contract, the way that we defined it last week, then we also can ask ourselves at that point, are there other rights or other legal remedies that someone might have? Now we'll explore some of those to quite a small extent in this subject. But again, fundamentals of contract law, it's called that for a reason because it's a fundamental foundational subject. So these kind of questions will come up, particularly when you get to equity and trusts, but also potentially in company law, in any of the commercial subjects really. Even in tort, you might be in a situation where you think, okay, this is something that feels like a contract problem, but I don't have a contract or I don't have somebody who can sue on it. Is there actually a tort here instead? And vice versa. It might feel like a torts problem. Maybe you can think about whether it could be a contract one. If you've got a contract, then you need to think, well, what are the terms of the contract? Because in order to sue on the contract, you need to know what rights and obligations sit under the contract, and particularly whether they're consistent with each other or whether you can read the contract in a sensible way. And if they are inconsistent, you've got to learn how to read the contract to make sense of it or work out what stays in, what gets left out. And then we also understand, when we can do that, what the specific rights of each of the parties are. So, big overview, it's kind of obvious at one level, why do we study contract law? So we can do these things, but actually it's part of that logic and unpicking process. So to determine whether we have a contract or not, our threshold question, we need to look at the elements of what a contract is. And there are, in essence, these four. Now, I could have just called this topic 2, topic 3, topic 4, topic 5. We've already done topic 1, right? Firstly, we need to work out whether or not there is an agreement. Now, we started talking about this last week. Easy way of thinking about agreement is we've got an offer and we've got acceptance. So we have an agreement, let's move on. Now, given that I'm devoting 2 weeks to this topic, you will work out that there's probably a little bit more to it, but not that much more. Okay, we don't need to overthink this stuff. If we can't identify where the offer is and where the agreement is, then we really need to ask ourselves the question of whether parties have reached a consensus. Because whilst that's the easy legal algorithm is the term I want to use, the formula for determining offer plus agreement equals acceptance, sometimes parties reach agreements, particularly in more complex transactions where any of you, now I know there's some people who work in law firms, can you identify yourselves again? You're scared of standing on the pillar of shame, aren't you? It's become the pillar of shame now. So you would have seen some sorts of contracts or arrangements where it's not as simple as I make an offer, you accept it without any negotiation, and we have agreement. There are situations where one draft gets prepared and it goes off to one party and they make changes to it and they come back and the other party says yes, no, yes, no, yes, no, it goes backwards again. And to identify at what point there was an offer made that was accepted is really quite difficult to do. Often documents don't even match each other. We call that the battle of the forms, and we'll get to that later. But the question becomes, actually, did the parties agree? Did they reach consensus? Because just because you can't see each of the elements of the equation doesn't mean that you didn't get the solution. And actually, even though we'll do so many cases that look at the question of whether there was a contract or not, actually, usually that threshold question isn't even in dispute. The parties agree they were parties to a contract. They just dispute what the contract meant or what their obligations were or whether they did in fact do what they said they would do or otherwise. So the other issue that happens with agreement a lot is this question of whether acceptance has been communicated or not. And we'll talk about that in a little bit more detail, but at the end of the day, in order to answer whether we've got an agreement, there are a couple of threshold questions we need to ask, and then we'll unpick it from there. The next question is there consideration? Now, I used the shorthand term price last week. And we'll talk the week after next a lot about what consideration means and why price is not a very accurate term at all. And consideration goes to the question of whether or not the parties have made a bargain. I don't want to overcomplicate things today. I'm on a new mission in my life to be less complex in the way I describe things. But we'll talk about consideration in a couple of weeks' time. This is a really important question, and the one that actually is lawyers tend to not think about that much in practice. And that's the question of whether or not the parties actually intended to be bound. Now, the cases in this area are so old on the whole, and actually in commercial contracts, it rarely comes up as a significant issue, but it really goes to that whole private law idea we were talking about last week. That whole question about whether the parties intended for this to be a private law between them, or if it was just a promise that they made in a social or a family environment, or which they just meant as an honourable thing to say. You know, the Lannisters always pay their debts. Is that a contractual promise? Is that an intention to be bound? Or is it a statement about family honour and fortitude? I don't know. Winter is coming. And then lastly, now this is so tied up in offer that we'll feel like we're flying past it when we get there. That question of certainty. So in order to have a contract, we need to have an agreement that's reached between the parties. There needs to be a bargain struck or consideration for that contract. We need the parties to evidence that they're intended to be legally bound. But it's really important, we also need certainty as to what they're bound to, what the terms of the promise are. So that's why this is so caught up in offer, and as we'll talk about in a minute, because in order, under the classic definition of a contract, you need an offer capable of acceptance on its terms that has been accepted and that acceptance has been communicated. So an offer that's capable of acceptance on its terms, in other words, is an offer that is certain. Now there's a little bit more, there are a few different elements to certainty. We'll unpick that in a couple of weeks, but we need those things. So that's another high-level view of the jigsaw puzzle box, and we start moving into the detail. So when you have a problem, and you're going to have a problem on Wednesday, when you have a problem, you need to start thinking about what you need to create a contract and why you need to know if there is a contract. So the what you need to create a contract are those things that I've just spoken about. You will be saying in your sleep. Agreement, made up of offer and acceptance. Usually, we can also look for consent, so we can't find that. Consideration, intention, and certainty. Do we have all of those things? That's what we need to make a contract. Any one of those things not there, we don't have a contract. So our question then becomes, what can we do about it? It's also important to know why you need to know if there is a contract. It's pretty straightforward. If it's my client will have to pay $200, go straight to jail, do not pass go, if they're bound by that contract. But there might be other reasons too. And we'll, in some of the cases, and I know you've done the reading, but you don't want to stand on the floor of shame, you will, at least one of the cases today, we've got these kind of odd reasons for why we need to know whether there's a contract. So I'll just save those for the big reveal later. Now, are you bored with IRAC yet? Yeah. Good, I'm really bored with it too. I think it's overly simplistic, but it works really well in exams in particular. So we are going to drill this into you, and it's as good a way as any to do a number of things. One is, I think it's a great way to read cases, to actually sit there with IRAC in front of you and say, okay, so you're doing a case summary, which is a really useful thing to do as you go. What was the issue in this case? What were the rules that were under consideration? How were they applied, and what was the conclusion? If you keep your notes in that way all the time from this point forward, when you're in an open book exam, you will know what to look for. You can colour code if you'd like to colour code, wouldn't you? I so colour coded. So I've got a little procrast organiser with me here. I would just accuse her. She's probably actually not a procrastinator at all, by the way. It's just I'm loving her organisational bent. So it's a really good way to keep case notes. It's also a really good way to just start with each problem. What do I think the issue is here? Now, personally, the way I learned this at uni, we called it MIRAT, which is slightly different because we would always look for, well, what are the material facts first? Because to work out what the issues are, you usually need to work out what the material facts are. Also, if you're like me and you attach yourself to a story, I often find it a lot easier to remember the stories of the cases and the case names. You know, the case that involved the bramble hot French hen or whatever, and the case with the carbolic smoke ball, or the case with the flip blade. I can remember the facts where I don't remember the names in the same way. I don't need to remember them, you don't need to remember them, you need a way of working out which ones they are in an exam because you're looking them up. So finding out what the facts are, that helps you remember, but it also helps you work out what's important in the issues. And I would always put tentative conclusion here. Any of us, unless we are Chief Justice Cardful, and even then we really need a majority of our mates on the bench to agree with us. Right now, everything's up for grabs, right? When we take something to court, we think that we've got as good a chance as any of winning, but so does the other side. So always couch your language in that tentative language. Pick a side and say why you think you're right, but never assume it's a lay down there. Always couch your words, particularly in academic context, with tentative language. Okay. Funny thing with this room, I feel like it's really awesome having that screen there to remind myself, but I can't actually read it, so I'm going to still have my back to you from time to time. With each of the topics, I try and do something like this. They don't always look as neat as a flowchart like this, but I try and pull it up so you can think about what the process is. So this is really what this topic we're going to start doing. So we've identified that this is a problem about agreement. We're just going to assume that to start off with, that the existence or otherwise of an agreement. And the first questions we're going to ask ourselves is there an offer? Now, this is an objective test. I'll come back to this at the end. I'll justify it as I go, but I'm really just trying to show you the logic of where I'm going. So in order to work out what an offer is, we need to work out what counts as an offer. We need to be able to distinguish an offer from different things. And we'll talk about some of those things. We'll also come back to that conversation we had last week about the difference between a unilateral and a bilateral contract, because it is important in the offer distinction. Assuming we've found an offer, the next question we have to ask ourselves is the offer still on foot? Has it been revoked, or has it lapsed or terminated in some way? Because in order for agreement to be made, we need to make sure that there is a live offer capable of acceptance on its terms that has been accepted on its terms. So we need to ask ourselves, has it been revoked? Assuming it hasn't, then we ask ourselves, using an objective test again, has it been accepted? And then has that acceptance been communicated? So actually the step in between, we will also explore the kinds of things that constitute acceptance. You know, is shaking hands enough? Is an email okay? Is a swipe right on Grindr okay? Let's look at what all of these different options might be. I'm probably messing up my dating platforms, by the way. I have no idea which is right, left, anything. And what happens if there's a difference between what is accepted and what is offered? What happens then? Okay, so that's the why. That's what we're going to do.